Nice to see you all. My name is Wayne Bernakevitch, by the way, for those of you who don't know me. I'm a lawyer with McDougall-Gawley Law Firm. McDougall-Gawley Law Firm is the oldest firm in the province. It's one of the biggest, and I like to say it's the best law firm in the province.
One of the original partners.
Yeah, right. You come right to the front here. I can keep an eye on you. You don't need smart Alex in this class. So I'm going to be doing a presentation. I'm going to start kind of up high at the top with a broad overview on wills and estate planning. And then I'm going to bore down a little bit in one area, the area of spousal trusts. So we'll do spousal and children trusts. This is an area that I think has tremendous potential, especially for business people like yourselves. And I'll show you how I think that might fit into some of your estate planning. So we'll do a broad overview, and then we'll kind of drill down. For those of you who do know me, well, I'm from a small town called Kelleher. Have you ever heard of Kelleher? When I was growing up there, Kelleher had a population of about 500, currently about 350. And as I was growing up, it really was kind of a nice, simple life. How many of you guys are from small towns or ladies? So you know what small town life is like. It's really simple. People generally get along. But in my day, the typical family was mom and dad, 3 or 4 children. And that was the typical family. And the small little businesses, people ran their little businesses. Farms were 1 or 2 quarters of land, and people farmed those quite contentedly. Back in 1972, the Income Tax Act was probably like about this thick. And in those days we never heard words like divorce, second or third marriages. We had no idea what a same-sex relationship was. Those things just didn't exist. If you fast forward to where we are today, things have changed dramatically. I had a lady counselor in my office yesterday. Her and her husband run a counseling business. And I asked her what business was like, and she said, it's off the charts. We're so busy, and by far the biggest component of our business is stress-related. We're counseling people all the time with respect to stress. And that's because our lives nowadays are very, very intense, very complex, very fast-paced. So nowadays you have situations like this. I'm a bit of a numbers person. But today, divorces, 50% of marriages today end in divorce, which is quite staggering. 15% of relationships are common law. So 15% of couples that are together are living in common law relationships. Same-sex relationships, 1 to 10%. I have a question mark there. Multiple situations where you have second and third marriages. 40% of people have wills, which means that 60% of people don't have wills. And if you looked at powers of attorney or healthcare directives, I suspect the number would be greater. Probably only about 30% or 25% of people have living wills or powers of attorney. So that's the kind of world we live in. And estate planning has gone from Elmont Bolton used to do the wills in Kelleher. He was the local insurance guy. You walk in, you sit in his typewriter, type out the will. If I die, everything goes to my spouse. If she dies, everything goes to me. If we both die, it goes to our kids. And he did all the wills for the people. Now that would be totally impossible because estate planning is so complex. There's so much going on. And the Income Tax Act and the regulations, if you look at it, it's like this. So that's the world we live in. I'm not sure my presentation is going to follow this exactly, but we'll start with what is an estate plan. So if you come into my office, what do I do for you? What do I look at? And I look at kind of 3 areas of your life. The first one there, where you're alive and you're able. You make decisions for yourself, but one of the things I like to do is to make sure that you have good advisors to assist you. So I would ask you about who your accountant is. Is he just a bookkeeper, or is she just a bookkeeper? I shouldn't say just a bookkeeper. Don't take that wrong. But is that what they do, or are they really accountants who can be proactive and give you good planning advice, good tax planning advice? Do you have a good insurance person? Do you have a good financial advisor? The second area would be an area where you're alive but you're unable to look after your affairs. And we look at a power of attorney. Who would handle your money? Who would look after your business? Who would deal with financial affairs, pay your debts? Healthcare directive. If you can't make healthcare decisions for yourself, who makes those for you? And so we talk about those things. If you don't have those things in place, you would have to get a court order if something happened to you, and a court order of this nature would probably run you $4,000 or $5,000 to get that in place. And then the last component, it's not really an area of your life because you're dead, but the area where you're deceased. We look at who your will, who your executor is going to be, who looks after your affairs, what assets you have in joint names. Sometimes it's good to have assets in joint names, and sometimes it's not. Those assets pass outside of the will. And then beneficiary designations on your RRSPs, your life insurance, and so on. So we would go over all of those areas for you. That's part of an estate plan. It looks at all areas of life, from right now to down the road. And in the current setting, we also look at, if you own a business, I would ask you in this first area, do you have a shareholders agreement with your partners, if you have partners? What happens if one of you dies? What happens if one of you is disabled? What happens if one of you wants to get out of the business? What happens if you don't get along with each other? So, as I say, it's a comprehensive kind of analysis of all of your affairs from right now to the very end. So a regular simple will would look like this. You'd have an executor, alternate executor. You would make bequests, specific things. So my Wayne Gretzky rookie card is to go to my eldest daughter, and here's how the general bequests go, and then who are the guardians for my children. So that's a very simple will, and that's what it would look like. If the husband dies, everything goes to the wife dies, everything goes to the husband. If you have two children and both of you die together, or one dies and then the other, half goes to either child, and if child one were to predecease you, that child's share goes down to the two grandchildren, a quarter and a quarter. That's a very simple will, and that kind of will works really well for many people, especially younger couples with younger families. We would also perhaps consider number 2 there, a common disaster. What happens to your estate if all of you died at the same time? Do you have a guardian? I mean, if you have children and don't have a guardian, you need a will for that alone. I mean, that in itself is very important. And then, do you want to give some money to the guardian? They're going to have extra children around. They may need some extra money. So there's a very simple will for you. As I mentioned, you might have complicating circumstances that come in. What do you do in a common law relationship? Here's something that many people don't know, and that is that if you live common law with someone, for the first 2 years, there are no issues, but at the end of the second year, what happens? You're legally married. So if you start living common law with someone, today, 2 years from now, you become officially married. You were legally spouses, husband and wife, or whatever. And there is a law in Saskatchewan that says when you become married, your previous will is void. So if you have a will now, our common law, your will is void after 2 years of living common law. And one of the issues is, with most people is, well, when do the common law relationships start? Yeah, we lived together for a while. I was at her place and she was at mine, and then, so when does the common law relationship start?
When does it start? When they get a house together?
It's just whenever the indicia of a marriage kind of all come together. Does this look like a marital relationship? Whenever it starts looking like that, then you're married. Then it starts.
Kind of subjective.
Very subjective.
I mean, what happens if you have a situation where, I happen to have this one, where they're not divorced yet, but the husband's already living with the mistress,
Well, you have multiple marriages right at the very bottom. You might have a couple of spouses.
So basically, he could lose.
Yeah, I mean, it becomes very, very complicating for sure, and we have lots of that going on again. That's it'll be interesting when those things start to kind of come through the court stream to see how judges are going to deal with those. Second marriages, lots of people, we're living longer, and besides divorces, people are dying and then remarrying. So you have lots of people in their 70s, 80s getting married for second marriages. How do they deal with their assets? How do you protect those assets for your own kids as opposed to your partner's children? You may have disabled beneficiaries. Again, same situation. Health care is better. Many people with dependent children. How do you deal with them? And again, like I say, the partnership relationships, you now have same-sex marriages, which are officially, legally marriages. So all kinds of complicating things that come in. I'm going to talk about spousal trusts, which are different than that simple will I showed you. I think these can be very beneficial for people in many ways. And it's a spousal trust that's set up within the will, so it's a testamentary trust. Some of you may have family trusts already. That's a document you sign that creates a family trust that can become, for example, a shareholder in your company. This is a trust that is created within the will itself. Right? Want to just flip it over, Jeff? And here's what it looks like in very simple form. So we're going to pick on the husbands today. So the husband dies first. You could have this in any kind of a spousal situation, but the husband dies first. Instead of his money or his assets going to the wife, it goes into a spousal trust. So the will says all of my assets go to a trust for the benefit of my spouse. And what would be the purpose of that? Well, if you look at those numbers, if the husband had given his assets to his wife directly, which is this component here, let's say she was making $50,000 and her husband's assets were making $50,000, she'd have an income of $100,000. She'd pay income tax of $40,000. The wife would receive $60,000 a year. Does that make sense? Everybody, these figures, by the way, are not precise. They're there for illustration purposes. So the wife gets $60,000 a year from just a simple will situation. If you create a spousal trust, what happens is the wife earns her income of $50,000. The trust earns income from the husband's assets of $50,000. They're each taxed as individuals. So the wife pays $12,500 in taxes. She nets $37,500. The trust pays $12,500 in income tax. It nets $37,500. That $37,500 then goes up to the wife, and she earns $75,000 that year as opposed to $60,000.
It's kind of like income splitting, except
It's like
the husband's not there.
It's income splitting.
Yeah.
I thought
Exactly.
you put things in trust to protect them from tax.
That's one of the reasons. Protection is there as well, and I'll go into that kind of in the next step. But one of the benefits is just totally tax driven. This is one of those benefits. It's totally tax driven. I'm doing wills now as well, and it doesn't show on here. I was telling Jeff on the way down, I've got to add this into our presentation. But what some people are doing is they're adding a second trust in. So they would put some assets into the spousal trust, and then they'd add a second trust down here called a family trust. And the beneficiaries of the family trust would be the spouse herself and the children and grandchildren. And so assets that go into there and earn income, that income could be split. If one of your kids needs money to play hockey this year, because hockey is very expensive, as we know, money goes for that. Or wants to go to university and needs a car or whatever. So I've prepared a few of these wills lately, and I'm just starting one for a business person, Regina, today, it creates a spousal trust or a family trust down there where you can do income splitting with adult children primarily and with your spouse. But again, the same kind of tax benefits could accrue through that family trust. Are there any questions about this? Do you follow this?
You have a family trust, I mean, it's dormant right now, but do you, for a spousal trust, do you have to, whatever it is you have to do for income tax and trusts every year, do you have to do the same?
You have to file a tax return.
Do for a spousal trust?
Yes.
as well?
Yeah. The spousal trust to file a tax return. So that's one of the downsides, but a very small downside. Simply, it files a tax return just like the husband did. The spousal trust. That's when the husband dies. Yeah, this happens when the husband dies. So when the husband is alive, you're both filing tax returns. When the husband's dead, you're still filing 2 tax returns. One, though, just for his assets. One of the questions is, what assets are these? So would it include the house that you own jointly with your wife? No, because if she's a joint owner, she just takes the house over, right? This would include any shares that he has in a company. So in your situation, if you have a husband and wife who are joint shareholders in a company, it would include shares of the husband that he has in the company. If he has non-registered assets in his name, it would include non-registered assets, any kind of investments. If he had life insurance, he could name the estate as the beneficiary, and the life insurance proceeds would go to the husband and then into the spousal trust and then be invested to earn income. Any kind of real estate that was owned by the husband in his own name, that all goes into the husband's estate and then down to the spousal trust. Mary?
Generally speaking, with insurance, does it not work that way unless you specify that you want the beneficiary to be a spousal trust?
No, what you would do is your life insurance, and I'm not the life insurance expert, we have some people here, but the life insurance policy would say my beneficiary is my wife if I die. And if my wife predeceases, my children. But what you would say is my beneficiary is my estate. And then the proceeds go into the estate and then down to the spousal trust. What some people are doing is if they have $1 million policy, they'll say half of the proceeds will go directly to my wife and half of them are to go to my estate. So $500,000 will go directly to the wife, $500 into the spousal trust ultimately. And that's one way to get funds into the spousal trust. You can what I say in my wills is that the trustee, who in this case is going to be the wife, the trustee has the ability to wind up a trust or to combine a trust. She could combine this trust with a family trust, for example, if she wanted to. So that's in the will. You have the ability to wind up the trust. If it's not working, you're just saying, hey, this is just not working. You wind it up. Or what some people will do is, if it's not working, they'll just kind of leave it. They'll let it kind of lie dormant for 2 or 3 years, maybe build up the assets within the trust, and then carry it forward from there.
The surviving spouse then can decide how much they take out in any given year.
Yeah, if she wants to take out, can you flip that back? If she wants to take out 37.5, she can take out the 37.5. If she wants to take out 30,000, then 7,500 goes back and becomes part of the capital of the trust. She can take it all out or leave it. And some of my wills, I say that the wife can encroach on the capital itself. If she needs some money for whatever, she can just encroach on the capital.
And why would you want that separate from the family trust? Why wouldn't you just use a family trust? What's the advantage?
Well, the family trust. I don't want to make this confusing, but the family trust is something that it's a trust that's created right now while you're alive. Okay, so, and the family trust that's created while you're alive typically would be perhaps a shareholder in your company. And then, assets come from the company to the family trust by dividend, and then you distribute it. But this is happening while you're alive. This is operating when you're dead. One thing you can do as well, and I've seen this. I've done this with some of mine. If you're in a second marriage situation and you want to preserve this for your kids, your wife is not the natural mother of your children. So you put things into a spousal trust and you say that the wife can take the income but not the capital. She can't encroach. So you provide for your wife while she's alive. She's receiving this income. When she dies, your estate is preserved here, and then it just flips down to the kids, and you can flip that over now, Jeff, if you would. So there you see what happens when the wife dies. Actually, two things are happening. There are two children here, so whatever's left in the spousal trust goes into a trust for child 1 and into a trust for child 2. So whatever's left here, half of it goes to this trust for child 1, half goes to this trust for child 2, and then the wife has assets as well, right? She's died with assets.
Wife number 1.
This is wife number 1. This is still the wife.
Okay, so in where there's a second relationship.
Yeah. She's dead. Wife. If you're in a second relationship, I don't want to get you confused. This is the current spouse. So wife number 1, I just talked about that. She's been divorced. She's divorced or she's dead. But this is the current spouse, and your will is with this wife here. The previous wife she's either.
So with the spousal trust, wife number 1, if this is wife number 2, is not within that.
She's not part of the picture. She's not part of the picture. So whatever's left in the spousal trust, half goes to child 1, half goes to child 2, or you might have it different. You might have 2/3 to child 1, 1/3 to child 2. And then the wife's assets, whatever those are, and those could include maybe the house at this time because she owns the house. The $500,000 from the life insurance policy that she got, half goes to child 1, half goes to child 2. And so now each of child 1 and child 2 have 2 trusts, 2 children trusts. Now do you see the potential benefit of those children having those trusts? It's a little bit of a quiz now.
What's the CT 1, 2, 3, 4?
Child trust 1, child trust 2,
Okay.
and then child trust 3 and child trust
Now I
4.
get it. Okay.
So child trust 1 and child trust 2 are for child 1,
Yeah.
and child trust 3 and 4 are for child 2. What would be potential benefits of those?
Deferred tax.
Yeah, same thing. Taxation again, right? They would each file their own, if they're earning income, they'd each be earning income, and so the child could do income splitting with the trusts.
They each actually filing as 3 individuals.
There'd be 3 tax returns being filed.
So if you have kids, have a family trust and a spousal trust, basically. If you have kids. If you don't have kids, you just need the spousal trust.
Yeah, that's right.
Yeah.
Yeah. Okay, Jeff, do you want to flip it over? And some of the benefits of this trust, well, lower income tax, as we've just gone through. Deferred capital gains. What that means is, deferred capital gains means when the husband dies, normally when you die, everything is crystallized and you have to pay. You're deemed to dispose of all your property, and you've got to pay capital gains. But if you put the assets into a spousal trust, you defer the capital gains. There's no capital gains paid on the death of the first person if the assets go to the spouse or to the spousal trust. You get income to the spouse. You can retain capital for the children, so the wife can get the income, and you can preserve your estate so the kids get it. Primarily in a second marriage, that works the best. No 21-year rule, and that simply means that with trusts we have this law that after 21 years the trust has to, in essence, come clean and pay any capital gains tax and whatever that would have accumulated. That rule doesn't apply in this kind of relationship with a spousal trust. So this thing can go past the 21 years. Now, some recent developments. So wherever there's good news, there can be some bad news. And as any of you who follow the budget, this year's budget, Jim Flaherty, who's the finance minister, this thing is so good that the government is looking at, maybe there's some money we can get here. And when the government needs money, they start looking at things like this. And so the government is reviewing testamentary trusts. And we're in the process of this now. There are organizations that are lobbying with Minister Flaherty. I know that Abe Taves is part of an organization that's doing that, saying that this should be retained as opposed to changing it. And of course, the people that these work best for, this kind of an estate plan, are people like yourselves. And I don't want to kind of infer that you would typically vote more conservatively, but this is the Conservatives' tax base that's being targeted here. And you'd be saying, why would you do that? Why would you kind of cut into a benefit for a lot of your core supporters? In any event, they're reviewing it, and I think that probably there are probably three options. Number one is they will do away with the ability to get the tax benefit. The second thing is they will perhaps grandfather. So if you have your will done now, and then they change the law, your will might still be, in force and still be able to benefit from this. Or maybe they'll find a middle-of-the-road compromise where you do get some tax benefit, but not the full tax benefit. I suspect kind of one of those three things will happen. Do you want to flip over? Okay, so what Minister Flaherty is proposing that would be that you would have the benefit of the income split for the first 3 years, and then you would lose it. So the worst case scenario, if he gets his way, or if he comes through with what he's proposing, you'd have the benefit for at least 3 years. So given our example, the spouse there would have been able to receive $45,000, $15,000 extra a year for 3 years. She would receive. Installment payments have to be made quarterly, and then there's potential of alternate minimum tax payable. So these are some of the downsides if the change goes through. I suspect if the change goes through, it will not happen kind of quickly. And I suspect it may be some type of perhaps middle of the road where there's some concessions given and some taken away. Some of the pros, in any event, there still will be some good benefits. You'll still be able to preserve your capital for your children so that you know your kids are going to end up with something when everything's all said and done. You can protect some of your kids who are kind of a little bit free and easy with their money. So if the money goes into a trust for them, you can say that they can only receive a certain amount of that the trust income every year until they reach 35. Hopefully they've grown up by then. But you can protect the assets from the beneficiaries themselves, so they're not going out and buying Corvettes and that type of thing.
What's wrong with Corvettes?
Nothing's wrong with Corvettes, but not for a 21-year-old. There could be an organized distribution, so you can kind of set up how the money goes out to the kids and so on. You might also protect the assets from a spouse. So if your kids are in kind of a relationship and you're thinking, I'm not sure about that guy, you put the assets into the trust for the child, and if your daughter and her no-good spouse aren't getting along, he may not have a claim against those assets. If they'd gone directly to your daughter, he would have a right to some of those assets. So you could protect it from a bad relationship potentially. You can have the trust professionally managed, so funds are invested, funds are dealt with in some organized way. You could encourage certain behavior. You could say, you will get these funds, or these funds will be payable if you go to university, or if you go to trade school, or if you participate in some type of charitable work. So you could encourage certain kinds of positive behavior by giving them incentives within the trust. If you do this, then you get some of this. There are some Before I leave the spousal trust area, do you have any questions? I just have some other things I want to just put back on the table, just to give you some thoughts on other areas. But yes, Slatin.
So if we create I guess if we specify trustee with a will today, hopes that it gets grandfathered, and later we need to make provisions for a no good son-in-law, will that cancel the initial trust and will it still make it qualified for being grandfathered?
If you redo your will, I suspect you'll lose the grandfathering. So what you do in this case, if you don't know what's going to happen, you can draft a will that anticipates certain things. So if you have 2 children now, but you may have more children, you can say to divide the assets into as many trusts as I have children when I die. And then you can put all the constraints and all the benefits and so on into the document, just in anticipation that you might have 5 children, but you might only have 2, but the wording can accommodate whatever number. So you can do the wording now to accommodate kind of future events. If they don't happen, it doesn't matter. The current wording will still work. If these future events do happen, the current wording catches those. This is I'm going to just talk about some other things that might be of interest for certain people. Really works well in a second marriage situation. So for example, you're in a second marriage situation. You have a family cottage at Katepwa that's been in the family for years, and you want to retain that family cottage for your kids. But you want your current spouse to have the ability to live there while she's alive, or to live in the family home while she's alive. So what you do is this. You say, if I die, my spouse has a life interest in this family cottage. She can live there and so on. When she dies, the cottage goes to my kids. So you can give the benefit of something to a second spouse and still preserve that asset for your own children. Does that make sense to everybody? Life interest. Using those more and more these days because you have more and more second marriage situations. That's happening a lot. Prenuptial agreements. You can. I have clients coming in on Friday, and they have lots of assets, and their kids have shares in their company, and the kids are all now in relationships with other people, and they're saying to their kids, if you want to continue to be a shareholder in the company, you have to have a prenuptial agreement with your partner. And the prenuptial agreement says that if they split up, that the partner does not have any interest in the company. So you address, one of the worst things you could have happen to your business is that one of your children is a shareholder, and that child's spouse all of a sudden owns some of the shares in your company when they separate or divorce. All of a sudden you have a shareholder in your company who is the divorced partner of one of your kids. So prenuptial agreements address that. So they're going to say to their kids, you have to get prenuptials, otherwise you're losing your shares. And that way they protect, the family business is protected from somebody outside of the family. Same thing with common law cohabitation agreements. If you own a business and you're living common law with somebody or cohabiting with somebody, you want to preserve your assets from this person in the event of a worst case scenario. It's like life insurance. You never want to, or fire insurance, you never want to draw on it because, but you want it there just in case. And this is what these things do. These are like insurance policies. Worst case scenario, you separate from your partner. That partner does not get part of your business. You can do these in one of 2 ways. You can say that the partner gets nothing, or you can say the partner gets other assets equal to the value of the business. Does that make sense to you? So if you're in a longer term relationship, maybe you want to say, well, she shouldn't just get nothing. She should get other assets equal to the business. I keep the business, she gets other assets. And that way they're still equal, but you keep the business. You'd have to value it at the time, and we can find ways to value. You can find business valuators. The worst case scenario, a judge will value it for you. So it'll get done one way or the other. Okay, well, I'll just go over this really, really quickly. Now we're getting down to some of the basics. This is for other presentations I do, not for this one, but I'm just going to go over it since I have some time. Key elements of a will. For those 60% of you that don't have your wills, this is what you're looking at. Executor. With husband and wife, you'd have mirror wills. They're exactly the same. The names are changed, that's all. I mean, husbands and wives should always have mirror wills. Funeral and burial. I'm not necessarily a big fan of putting burial instructions into a will. And I'll tell you the reason why. Is because people then think that they've got the job done. They don't tell anybody. And the person dies, has the funeral, they're buried, and then they read the will a couple of weeks later and it says, I want to be cremated.
Oh.
You know, so what I say is if you have burial instructions or funeral instructions, tell people now. Give it to them right now before you die. Joint assets, one of the biggest problems I used to see, I don't see it happen as often anymore, but one of the biggest problems I used to see is parents putting assets into joint names of their kids. And that can have all kinds of bad implications. So before you have your mom and dad put assets into your name jointly, or before you as mom and dad put assets into your kids' names jointly, talk to somebody about that. Talk to your lawyer or a financial planner or somebody about the pros and cons of doing that, because you can have all kinds of negative things happen. One negative thing, I've run across this a number of times. Mom put the house into joint names with her 4 kids. Then she needed the money. She wanted to sell the house, and 2 of the kids said, that's our inheritance. We're not agreeing to the sale. And they wouldn't agree to the sale of the house. Mom needed the money.
Her status as primary residence, so the house becomes taxable.
That's right. You can lose your capital gains exemption on the sale of the residence. One of the kids, if you put it into joint names, one of the kids could do something wrong, end up being sued and having a judgment against them. You know where the judgment goes? It goes against the title of that house. So many negative implications. So very careful about joint assets. And beneficiary designations, well, again, there are certain ways to do it properly. Don't just kind of check off the little box where it says who you want your beneficiary to be. Talk to somebody who knows the full story about that. So that's part of yours. Validity of a will. I have people come in saying, well, I just wrote something on a piece of paper, and well, unfortunately, that can be good enough. You can have a will just in your own handwriting. There is the famous Robert tractor story, which you may have heard, about a farmer who was pinned under his tractor by the wheel and scratched on the fender of the tractor, all to wife. And the fender of the tractor is regarded as a valid will, valid holograph will. And
What does holographic mean?
in your own handwriting.
Oh, okay.
And apparently that fender used to be in the Crawford courthouse, because you have to retain the wills on record.
It's actually at the College of Law.
Is it College of Law now? Okay, it's actually the College of Law now in Saskatchewan. So, if you do a will in regular form, you have to have 2 independent witnesses. I had a will where people did these kind of Wilson stationary wills. You know those things you used to get, and they did it all up, and they then had one of their kids witness, and if a beneficiary or a spouse of a beneficiary witnesses your will, that part of the will is invalid. You have to have 2 independent witnesses witness your will at the same time. I had another lady who did one of her Wilson stationary wills, signed it up, had her neighbor over for coffee one day. The neighbor witnessed the will. Next day she had another neighbor over. The other neighbor witnessed that will. That will is not valid because the witnesses have to be present at the same time. So don't get a Wilson stationary will. Go to a lawyer. I've talked to you about capacity and undue influence. This is becoming a really big area. And the reason I think is fairly obvious. The reason is because people are living longer. You have Alzheimer's, you have dementia, and people are preparing wills when they're in some of these situations, and the issue is, were they competent when they signed the will, when they gave the instructions? I had a person call me yesterday. The father is kind of in between. He's in and out of kind of proper capacity. 3 of the kids are fighting. One of them's taken them off to this lawyer to get a will done, and somebody else has taken them off to another lawyer to get a will done. It creates all kinds of issues. I'm not sure that I even have an answer for the issue, but I can tell you what the issue is. Capacity is very important. Undue influence is very important. Especially among the kids, kind of pulling mom or dad this way or this way. It's becoming more and more of a problem. This is a growth area for lawyers. There will be litigation galore because of the longer lifespans we're leading.
So when you have your capacity, do your will. Very
Do your
simple,
will.
Right.
Exactly. Yeah, don't wait. I can tell you stories. I've been in hospital rooms at midnight on a Saturday, writing out a person's will on a piece of paper and having them sign, and they die the next morning. Don't do that. Do you have anything else, Jeff? Are we coming close? Okay. What happens without a will? I can tell you it's not ideal. The government doesn't get all your money. People say, well, the government gets all your money. Well, it doesn't really happen that way. But your estate is divided according to specific legislation. That's some of what it says. Ultimately, your spouse and kids, if you don't have any spouse or children, will go to parents, siblings, aunts, uncles, nieces, nephews. There's a whole kind of a descending order of entitlement to your estate if you die without a will.
And also the public trustee can get involved.
Public trustee can get involved in certain instances, yes. Power of attorney. I think that these are very important. I think you need a power of attorney. In the old days, it wasn't me. In the old days, my wife could walk into the bank. I wouldn't do it. She'd walk into the bank and say, "How much money does Wayne have in his account?" And they'd say, "This and this," and you say, "Okay, great. Can you give me $20 or $50?" And they just do it. Nowadays, if you walk into a bank and ask about your spouse's account, they won't even acknowledge that your spouse has an account there. Everything is just like this. So you need a power of attorney where you appoint someone to look after your affairs for you, because banks will not be cooperative with you. Neither will anyone else. You need the power of attorney where you appoint someone to look after your affairs for you.
So it's not necessarily your spouse,
No, it can be anyone you want.
but it's not automatically, I guess, is what I'm
No,
saying?
it's not. You need that written piece of paper. I think that's critical.
Sorry,
I'm
what
sorry,
kind
it's
of
fine.
person would be a good power of attorney?
Your spouse, and then after that, some people will put down, if you have a child who's really mature and capable, or a very good friend of yours who's very mature and capable, those kinds of people. Spouse.
Children.
I don't have any problem with children. Sometimes you'll have 2 children, and they have to do it jointly.
Yeah.
Okay, what do we have now next? Healthcare directive. Healthcare directive is a living will. Typically, what you'd say in a healthcare directive is this: if I have a severe terminal illness, there's no chance of me recovering, I don't want to be kept artificially alive. And then it'll say, if I can't make healthcare decisions for myself, then I appoint so-and-so to make those decisions for me. And that's essentially it. I have husbands and wives come in. It's kind of funny because the husband will say, I'd say, "So who do you want?" And he'd say, "Oh, I want my wife." And the wife would say, I'd say, "And who do you want?" And she'd say, "I don't want him. I want my oldest daughter," or someone. I've had that happen many, many times. And the husband usually understands. I mean, he says, "Yeah, that's fine with me." So, healthcare directives, and those are some of the things you can put into your healthcare directive. I think these are excellent as well.
This is if you're ill in the hospital and you can't.
You can't make
you're in a
healthcare decisions.
coma.
You can't make healthcare decisions for yourself.
Okay.
Exactly. This gives direction to somebody. One of the biggest things where I've seen this, really worthwhile would be when someone really is terminal, and the person, one of the spouses says, this can't go on. We have to let Dad go, and the kids are really uptight about it.
Yeah.
I mean, I've seen that. They're really uptight. You pull out the living will and say, this is what Dad wanted. It says it right here. He says he doesn't want to be kept artificially alive. And it helps that situation. This is what Dad wanted. Yeah, we're okay with that. It's not Mom's decision anymore. It's really Dad's decision as recorded in the healthcare directive.
So how's the medical community reacting to this kind of?
Pretty good. I have a number of doctors who are clients, and they will say, yeah, we're okay with these things unless the instruction is really bizarre. If the instruction is really bizarre, then doctors won't go along with that. If there's an impasse, you have the ability to go to a court, and a judge will decide how things work. But typically, doctors are okay with them.
You're talking about just removing life support? Like just
Any kind of treatment.
Any kind of
Might be
treatment.
some kind of treatment. They may say, we don't want him to have any kind of that treatment. We just want to kind of put, a pyramid under his bed and let the kind of
Oh.
the aura of that heal him. I
Oh,
mean,
yeah.
a doctor wouldn't go for that.
Well,
What
they
if
are.
there
Yeah.
is not a healthcare director? What will the doctors do?
They would go to the nearest relative. If there's no healthcare directive, they'll go to the spouse. And if there's no spouse, they then go to the parent. Unless they're children, then they go to the children. So there's kind of an order for those as well under legislation. Powers of attorney don't have the same thing. Healthcare directives do have an order of preference. Typically, lawyers make this package of material affordable for you. It shouldn't be money that scares you away from doing this kind of planning. And then I think we have a list of some of our lawyers in this area. So we do have an estate group at McDougall-Gawley, and those are some of the names there. So that's it. Unless you have any questions, any more questions, that'll be it. If you want to ask me questions after this is over, I'll stay around for a bit as well. Okay? Thank you.
Thank you.